This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today I'd like to speak about a case that explains why insurers should never sue each other and why a pedestrian's no-fault claim belongs to the insurer assigned to deal with it in the state of Michigan. Insurers are professional litigants. They are sued and sue often. Usually they avoid suing other insurers for fear of making precedents that will affect the entire industry. In Beth Bracy versus Farmers and a bunch of other people and insurers, including GEICO Insurance Company, the Michigan Court of Appeals on October 13, 2022, found that the insurers involved should have avoided the litigation against each other and voluntarily resolved the dispute with the injured person. Instead, they litigated as to which insurer should pay and which was first and who was on first. And like the Abbott and Costello routine, nobody was satisfied with the result. On March 7, 2012, GEICO issued an automobile insurance policy to Marcus Nichols. 3 years later, Marcus added a 1993 Chevrolet Lumina owned by his mother, Yolanda Nichols, to the policy. Yolanda was identified as a driver on the policy, but she was not named as an insured on the policy. She was driving the Lumina when she was involved in an automobile accident with Beth Bracy, a pedestrian, on August 23, 2014. Bracy sought personal protection insurance, PIP benefits, under the Michigan No-Fault Act. Through the Michigan Assigned Claims Plan, the MACP assigned the claim to Farmers, and Farmers paid Bracy PIP benefits for her accident-related injuries. Bracy was dissatisfied and filed a complaint against Farmers and Nichols, alleging bodily injury liability against Nichols and alleging Farmers had unreasonably and unlawfully refused to pay her PIP benefits in accordance with the No-Fault Act. Farmers filed a third-party complaint against GEICO for reimbursement. Later, Farmers sought summary disposition against GEICO, contending GEICO was highest in priority for Bracy's benefits. GEICO also filed a motion for summary disposition against Farmers, arguing that Farmers was highest in priority for Bracy's benefits. The trial court granted Farmers' motion. GEICO appealed to the Michigan Court of Appeal, which remanded to the trial court for entry of an order granting summary disposition in favor of GEICO because GEICO was not the insurer of the owner, registrant, or operator of the Lumina and therefore had no obligation to pay Bracy's PIP benefits. Farmers contended that Nichols' vehicle was insured under the GEICO automobile insurance policy and thus Bracy was entitled to recover no-fault benefits under the policy. In Michigan, an uninsured pedestrian who suffers accidental bodily injury must seek PIP benefits from insurers in the following order of priority. 1. Insurers of owners or registrants of motor vehicles involved in the accident. Or 2. Insurers of operators of motor vehicles involved in the accident. When no such insurer exists, the uninsured pedestrian may seek PIP benefits through the MACP. In this case, the trial court did not err in granting summary disposition to GEICO because GEICO is not the insurer of the owner, the registrant, or operator of the Lumina and therefore was not obligated to pay Bracy's PIP benefit. The Court of Appeal concluded that in this case it was undisputed that Marcus was neither the owner nor registrant of the Lumina. Thus, the Lumina was not an auto for which he was required to maintain security under the Michigan Insurance Code. Accordingly, Bracy was not an eligible injured person under the GEICO policy. The named insured must have an insurable interest to support the existence of a valid policy, and an insurable interest in property is broadly defined as being present when the person has an interest in the property, as to the existence of which the person will gain benefits or as to the destruction of which the person will suffer loss. Since Marcus had no insurable interest in the Lumina because the Lumina was solely owned and operated by her son Nichols, and there was neither evidence that Marcus had use of the Lumina such as to be considered an owner under the statutes, nor that he intended to acquire the vehicle, the Lumina's existence did not afford Marcus any benefits, and the destruction of the Lumina would not have caused him any loss. GEICO argued that the trial court's grant of summary disposition in its favor was also proper because the insurance policy was void in light of Marcus's misrepresentations in obtaining that policy for a vehicle in which he had no insurable interest. The trial court dismissed GEICO's misrepresentation argument as moot because it was granting GEICO's motion for summary disposition on the basis of priority. The argument remains moot on appeal for the same reason. And as a general rule, an appellate court will not decide moot issues. In my opinion, why this litigation between insurers took place is difficult to comprehend. Farmers was assigned by the state under the MACP to provide benefits to the injured pedestrian, and it did so as assigned. Then it claimed GEICO was obligated to pay the benefits even though it did not have an obligation to do so, and the trial court and Court of Appeal agreed. The lawyers' fees and time of the court could have easily been avoided by the two insurers working together to resolve their differences, especially after they lost twice and then kept asking the court to reconsider. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who asks by simply clicking on zelma.com/blog. You can subscribe to the blog, and then you will receive notice every day it is issued, usually 5 days a week. And you can also subscribe to these videos on rumble.com or youtube.com. If you watch the videos, please click on the like button or the rumble button as you do so. You might also be interested in subscribing to my locals community or to my Substack publications, or both. Thank you for your attention.